All righty, let's go on the record on cause number DC 1918220, Zubrick versus Gonzalez. Council, make your appearances.
Your Honor, Robert Miller on behalf of Charles Zubrick.
And Your Honor, Christopher Norcross on behalf of the Valley View Park Estate Homeowners Association.
Good morning, Your Honor. Keith Kramer on behalf of the HOA.
Caitlin Coker on behalf of the Sorensen, Smelser, and Phillips defendants.
Greg Fell for the defendants, Francisco and Mary Ann Gonzalez.
Kelly Milligan for defendant Ronnie Henderson.
Let's proceed.
Thank you, Your Honor. It's the 11th day, the 11th hour, but I don't see any peace coming fast enough. That's my little joke for the day, Your Honor.
Okay.
We're here on trying to get a receiver for Valley View Park Estates. And there's a lot of reasons for doing that. Under the Business Organizations Code, the governing persons of the entity are deadlocked. In the management of the entity's affairs, the owners or members of the entity are unable to break the deadlock. And irreparable injury to the entity is being suffered or is threatened because of the deadlock. There's spent a lot of money on this, which is in my motion, Your Honor, that they're just spending money and we can't get. There's been 3 votes that have been that have been found to be fraudulent and were not done correctly, and there had to be a recount. It's gotten very expensive to do the recounts, and we haven't been able to do all of them, and that's why we filed this motion to have a receiver to try and get this stuff worked out without the problems with the votes being cast early and cast under different at times when before they even started. And that's why we are here today, to try and get a receiver. There's the Business Organizations Code, there's Civil Practice and Remedies Code allows this to be done because of the fraud that's going on, because of the property is being misapplied or wasted. I got a couple of photos in there yesterday that show some of the stuff is not being taken care of. The landscape's not being taken care of. I also on my motion is the amount of money being paid to these attorneys. Now, I'm not to say that the attorneys aren't allowed to be paid, but this is something that just keeps going on and going on. There's something like $74,000 in legal things that have been paid over the last couple of years on this. You know, this all started very simply, Your Honor, where we filed a motion that the fences were put in the wrong place, and the court agreed with that and said, yes, you violated the declaration. They've tried to change the declaration 3 or 4 times with the votes keep getting recounted and redone, and they're fraudulent. And it would be best if we could get a neutral receiver. I've got Brad Jackson on the order, and he's an attorney. He has nothing to do with this case. He's standing by if you need to talk with him today. But we think that we're entitled to the receiver to try and get things done, because as the court may or may not know, things don't get done. There's votes, and then there's recounts, and it's just something that needs to get stopped. We need somebody else to come in and take care of this. And I think the statutes provide for it. Both the Organizations Code and the Civil Practice and Remedies Code allow this. And let's see if there's anything else wonderful to talk about. I think that's about it, Your Honor. I'll pass at this time. There was one of the ballots was signed by somebody who doesn't even live in the association anymore. Shouldn't have voted at all. And that's the kind of things we're dealing with, and we need to stop it. To get somebody who will do this without worrying about that, what's best for them. And that's the whole thing here. Whatever they've done has been best for them, not for the HOA. And that's another reason for the receivership, Your Honor. We need to get somebody who's not going to just do what's best for them. Now, I understand that they want to have some kind of stuff so that people can't see them from the street, but there's other ways to do that other than putting structures in the areas that you can't have structures. And so we would, at that I will pass again, maybe again, but that's all I got
Okay.
for you.
So who else is joining in this motion to appoint receiver? Mr.
Honor.
Bell, Ms. Coker, are you joining in this?
No, Judge, we are opposed.
No, Your Honor.
We are also opposed, Your Honor.
Okay. Let's go ahead and proceed then, Mr. Who else wants to speak before I turn it over to Mr. Norcross?
I have a brief comment, Judge, if I may. I'm
Sure.
not exactly a party in interest, but I would like to point out the evidentiary issues. If this court were to be inclined to grant that, there would be no evidence on which to do so. The only evidence provided was 2 authenticated pictures of greenery in the front. And one happens to be from November, apparently. The other happens to be from January. I know very little about greenery, but I do know that some plants grow in November and some plants die in January. So that's all I have to say, Judge.
Mr. Fell, did you want to say anything?
I think Mr. Norcross is in a better position. I'll just say one thing that caught me off guard. I mean, Mr. Miller referenced 3 to 4 votes that have all been invalidated. My understanding was that the most recent vote was upheld in arbitration through the appeals process under the declarations, and that was the second contest to the vote. So my understanding is that vote passed, the declarations were amended and duly filed with the deed records. But I'll turn it over to the respondent of this motion, the HOA.
Mr. Milligan, did you want to say anything?
No, Your Honor. I mean, I'm a little taken aback by Mr. Miller's sudden concern for judicial economy and all the money spent on legal fees. Certainly, Mr. Zubarek has something to do with that himself. But as far as the merits of the motion go, such as they are, I will leave that to Mr. Norcross. Thank you, Your Honor.
Mr. Norcross?
Your Honor, I appreciate the opportunity to address the court. As Ms. Coker, Mr. Fell, and Mr. Milligan have aptly pointed out, Your Honor, each in their own respective ways, there is no evidence to support this motion. The statute that governs the appointment of a receiver is found in the Texas Business Organizations Code, section 11404. And Your Honor, the standard is clear. It's an extraordinary remedy that the court should use as a remedy of last resort. And certainly, Your Honor, only on a finding based on significant evidence of fraud or some other wrongdoing. We don't have that in this case. What we've got is Mr. Miller's statement of, things just don't get done. Well, what he doesn't quite complete that sentence, right? Things just don't get done to his and or his clients' desired outcome, right? They don't achieve the result that they want to achieve. And so then they file motions such as this. They filed the lawsuit initially. And Your Honor, they bring issues.
Let me ask this, because this is kind of the area that, we've been dealing mostly with these easements, but I know there's an arbitration out there that involves the votes and whether or not the votes have been valid. And I think, was it Harlan Martin that supervised some of these elections? Is that right?
Yes.
Mr. Martin. Judge Martin was responsible for one of the recounts, and then after that recount was performed, Your Honor, Judge Martin performed the recount on the second vote.
And why did we need multiple elections on these things or multiple votes?
After the initial vote that took place, Your Honor, in March of 2021, Mr. Zubarak and company raised an issue about whether or not the vote was conducted fairly and properly. There was a recount that was performed. Judge Martin performed that recount, and there were certain early votes that apparently had been improperly counted. And so a second election was called and held on July 1st, and that election or that vote was again challenged by Mr. Zubarak. And this time, Judge Terry Lynn was asked to perform a recount.
Who is the second person you said?
Terry Lynn, Lynne.
Okay.
Former Collin County judge, Your Honor.
Okay.
He performed the recount and found no issues that would negate the vote, Your Honor, or overturn the election results.
If I may, Your Honor, I apologize. This is Keith Kramer for the HOA. There was no, he keeps banning the word fraud around. There was no fraud found. There was a technical problem that the judge found with the wording of some proxy ballots and whether they were specific enough or whether they got held open too long and whether they could be counted. So as a result, we did have to do a second election. And by the way, both elections passed, but the second one has not been overturned.
And was there a third vote as well?
Not on the issue of fences, Your Honor. The third vote that Mr. Miller referenced was a vote relative to the appointment of board members. They were voting on the election of board members. And frankly, they just didn't like the outcome of that vote. They didn't like the individuals that were elected to the board.
And there's no evidence.
And there's no
in front
evidence
of this court.
If you look at the motion to appoint the receiver on page 4, the statement that they make is we believe that these individuals were elected fraudulently by the same voting irregularities that occurred in the March and July election votes. They believe it, but they have no evidence of it. They offer the court no evidence of it. They offer opinion.
Was that vote supervised as well by Harlan Martin, or who supervised, or did anyone supervise that vote?
Well, none of the initial votes were supervised. The first two votes were challenged. And so upon challenging, Judge Martin and Judge Lynn performed the recount. As far as I know, the third vote that they're complaining of hasn't been challenged. And so there hasn't been, a judge appointed to review the vote.
So that currently those board members are in place.
That's correct.
Okay.
And so really all of this just gets back to the fact that, Your Honor, they don't like the way the elections go. And as Your Honor knows probably better than anybody else involved in this hearing, having run for office, right? If you don't like who is elected, you change it by voting that person out and voting somebody else in. And the bylaws provide for that. They haven't been able to either do it or take advantage of that process. And so they don't like the outcome. So they're coming back to the court for what I believe is the third time to request the appointment of a receiver. This is not the first time the court has been asked to consider this.
We've never actually had a hearing on this, though. This is the first time we've had a hearing, I believe.
It may be the second time for the hearing. I think they tried
I know that he filed it and he pulled it down and then he refiled it. Mr. Welch, I didn't know you were joining us today. Are you here for this hearing?
I am, Judge. I'm sorry. I got held up, Judge Evans, in another hearing in County 4. So I'm sorry for being late. I'm not going to argue, but I'm just kind of observing.
Okay. Anything else you want to say, Mr. Norcross?
No, Your Honor. I think everything else has been aptly addressed. Again, the issue with the fee.
So just to be clear, the only election that was actually required to be reheld was the first one with the proxy votes. All the other ones have stood. Is that correct?
Your Honor.
Okay. I misunderstood that. I thought it was more than that. Okay. No. Mr. Miller.
Your Honor, the interesting thing is after Judge Martin said these were not done correctly, they went and got somebody else to do it. Mr. Lynn, who for some reason got done. And looking, there's an email that Mr. Lynn sent about getting the votes done early, which is not allowed. And that was attached to the motion also. I think.
Is the board currently deadlocked? Is there some kind of deadlock on the board?
The board is not currently.
No.
Your Honor. There are no issues. There are no issues with the board. There are no issues with the board. The board is functioning as the board is supposed to function. The business of the HOA is being conducted as it's supposed to be conducted. As Ms. Coker pointed out, the things that they complain of with the landscaping, for instance, right. If I look at my lawn in November and January of 2021 and 2022, right, it looks the same as the pictures that he's sent in and is using to show the court that the HOA is not doing its business. It's absolutely conducting its business.
Somebody's talking, I'm not sure who, but Mr. Miller.
Sorry, Judge. If I could, Mr. Zubarik's here. Could he say something to explain it? He knows it a lot better than I do. If that's okay with the court.
Does anyone have an objection to that, Mr. Norcross?
We absolutely object, Your Honor.
Yeah, it's
highly inappropriate.
Yeah, that would be inappropriate in this situation. If you want to call him as a witness, I guess you could do that briefly, but I'm not going to just let him just start talking.
Well, I would call him as a witness, Your Honor, yes.
I need to be able to see him on the screen.
Well, there he is.
There we go. All right, sir, please raise your right hand. Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? Nothing but the truth.
Yes, I do.
Let's proceed.
All right, Mr. Zubarik, what's your opinion about why you need a receiver in this case?
Your
There
Honor,
are
we
several.
object to the entire line of questioning here.
Oh, overruled. You can answer.
There are several reasons for needing a receiver, Your Honor. There have been 2 votes to change the declaration. The first one was overturned because of the wrong use of proxies. We didn't know at the time other things were going on with regard to what they call voter harvesting. Voter harvesting is when they go out in advance of an election and collect votes before there's even an announcement of the election or even a dissemination of what the election is about. We got evidence of that in the second vote to change the declaration. And we got copies of the ballots from the first vote. The first vote, over 90% of the ballots were done a month or more or less in advance of the notice date. That election was overturned by Judge Martin, so we didn't do any more with it. The second election, they collected over 50 votes. They're required to have 58 to make the change in advance of the notice. And there's an exhibit in this submission. It shows an email from Terry Lynn, who lives in the association and basically runs the association from behind the scenes. He was head of the litigation committee. He's been a board member for years. He's a present city councilman, but he runs the association and the people on the board do what they're told by him. It is very obvious and it can be proven. The other proof we have is all 3 elections were videotaped. They were videotaped to prove that the delivery requirements of the absentee ballots were not adhered to. The delivery requirements say you can submit an absentee ballot either electronically or by mail to the management company, or you can deliver it in person at the time and place of the meeting. All 3 meetings that were videotaped show that less than 10% of the absentee ballots were delivered at the time and place of the meeting by the person who made them. They were brought to the meeting by Terry Lynn or one of the board members and counted, and they shouldn't have been counted because the delivery requirements on the absentee ballot don't allow that. So they're fraudulent. And that's the whole contention. There's no way for us to overturn this board because we can't get a fair election. We need a receiver so we can get a fair election. They do not. The second reason for receiver is that they don't follow the CC&Rs. They sue me for not following the dispute clause of the declaration. They don't sue themselves for putting up fences, which Your Honor ruled were a violation of the declaration. They don't sue a neighbor that they bought their house from who puts up a metal seam roof, which is a violation of the declaration. They don't sue 20-something people in the neighborhood who have street signs or lawn signs up. They've been up for over a year. It detracts from the aesthetics of the association, drives down property values. They don't do anything about it. Terry Lynn puts his daughter on the board through fraudulent votes. She drives a commercial vehicle and she parks it outside, which is against the declaration. And she was questioned on that in a meeting, and she said, well, the city doesn't care if I have the vehicle out there, so the CC&Rs don't apply to me. She said that in a board meeting where she was elected. Yes, she sits there and she's occupying the seat. Her father, Terry Lynn, tells her what to do and votes the way he tells her.
Okay, this is going to get to be a narrative at this point.
It's also, it's hearsay, it lacks foundation, it's.
I object to hearsay as well.
So let me just let's go through these one at a time. So he's claiming that there was some irregularities in the second election. Why wasn't Harlan Martin brought back for the second election? Why did you guys kind of switch horses, Mr. Norcross?
Your Honor, I don't know why Judge Lynn, and again, right, we're talking about another former judge.
But is he a member of the association, or is this a separate person?
No, Judge Lynn does live in the neighborhood, but he's also a former judge and is currently, on the city council. My point is, right, all of these issues were vetted in the arbitration that followed the second vote, and the vote was upheld. There are no issues, Your Honor, remaining with the second vote. The results of the second vote have been validated. And so these irregularities, to the extent that they were concerned about them, have either been raised or waived. We're talking about a non-issue here with regard to the second vote. And the first vote was simply a technicality. And there is no evidence of any of the issues that Mr. Zubarak, with respect to Mr. Zubarak, there is no evidence of any of the issues that he's raised in his narrative testimony. He's quoting people that he's talked to. He doesn't have a basis to do that. He says that there's evidence of voter harvesting. They've not presented any of that evidence, Your Honor. It doesn't exist.
If I may, Your Honor, and it's telling that the question that started the narrative was, what is your opinion?
Exactly.
This is just his opinion. He didn't offer evidence, and there's no competent evidence in front of this court on any of these items he's talked about.
Actually, Your Honor, attached to my motion on page 12 of 13, there's an email from Francisco Gonzalez, or from Terry Lynn, excuse me, to Francisco Gonzalez about the HOA meeting scheduled for tonight. I will hand out and start collecting absentee ballots for the vote on the amendment to the declaration. And that was a page label G0189 also, Your Honor. It's nothing new to these people. They have not called a special meeting yet, but plan to do so. Well, that's not the way things are supposed to go. And that's why they got rid of Judge Martin and got Mr. Lynn, which probably shouldn't have been done because he's a member of the HOA and he shouldn't be in there.
But Judge Harlan Martin was the arbitrator that actually confirmed the second vote, correct?
No, sorry, Judge. I was more involved in this process, so I can give you a better understanding. Judge Martin was the first vote only, and the way that process worked was Judge Martin requested briefing, and I got all the votes and everything the first time. The second time when we challenged the vote, it was actually Mr. Casey Meyer, who I don't see him here, who was representing the HOA on that. they took it to the Collin County judge. I never got the votes or anything. There was no briefing. Basically, we filed our objection, and then 30 days or something later, we got an order from the Collin County judge saying it's all approved or something. That was not Judge Martin at Jams that time. That was a second different person.
And maybe I misunderstood. Then was that not appealed though to the arbitrator, and the arbitrator made a decision that the vote was done correctly, or is that incorrect?
Yes, there was a ruling, not really an arbitrator, but yes, sir, there was a ruling the second time too by not Judge Martin, but a different person.
But at Jams?
No, it was like a former Collin County judge. I can't remember who it was, but it was not Jams. We never even got an input on who that second person was. Basically, the first time we said, hey, we're going to challenge it, Mr. Casey Meyer, who do you agree to be kind of our resolution guy? And we both agreed to Judge Martin. And then the second time I challenge it, Mr. Meyer just runs to the new person who I had no idea who it was. And next thing I hear, hey, it's all upheld. So I don't know how that second person got engaged or what happened there, but that wasn't by agreement or any one of us on our side involved at all.
I guess I don't quite understand how this arbitration provision works then. The arbitrator was appointed. How was the arbitrator even appointed, and who what was the arbitration? How did this all work?
So under the property code, Judge, when there's a challenge to a vote in an HOA, and I don't have the case site in front of me. I can get that to you. It basically gives you a couple options of one, who's qualified to be an arbitrator on this issue, or we can agree. And it's not a very well written statute. Let me see if I can find that for you quickly, Judge. It's actually a procedure under the property code.
And Your Honor, while he's looking, just to note, one of the options to challenge a vote is not to have a receiver appointed for the HOA. I mean, if they want to challenge the vote, I suppose they can do so, but the receivership is not the proper remedy.
Well, but they've already challenged the vote. I mean, that's the important issue here. They challenged the second vote. They lost the challenge to the second vote, and now they're claiming it's fraud that they lost.
Yeah, it does seem like, Mr. Welch, that the issue is if this was a fraudulent vote and the process for determining that wasn't done correctly, then that should have been brought to the court's attention as opposed to the receiver. As I understand this, Mr. Welch, do you disagree or?
I don't necessarily disagree with that, Judge. My understanding is the receiver motion goes above and beyond this one issue. This is just kind of, hey, it's another piece of why there should be a receiver. I've got that site for you, Judge. It's Texas Property Code section 209.0057, and that deals with the recount of votes.
And is one of the remedies for a recount of votes appointment of a receiver?
No, I don't think anything in the property code right there deals with a receiver, Judge. I think the receiver request is separate and apart from that. Now, I'll go back to not talking, Judge. I'm sorry. Just no one seemed to know the facts, and I want to make sure you had a full.
Okay. Thank you. I appreciate that. Did you have any other questions, Mr. Miller?
No, Your Honor.
Okay. Anybody want to cross?
No, Your Honor.
Ms. Coker?
No, Your Honor.
Mr. Fell?
No, Your Honor.
Mr. Milligan?
No, Your Honor.
Okay. All right. Based on what I've seen so far, I'm going to go ahead and deny the request for a receiver. Anything else we need to chat about today?
No, Your Honor.
And I want to make sure there's been some motions to sever filed. Have I ruled on all of those? I think I have.
You have, and I owe you an order on that, and we'll have that for you today.
Go ahead and get me an order on this as well. Have you already submitted an order on this?
All right.
And as always make sure at the beginning of the order, it says on February 11th, 2022, the court considered the following motion, blah, 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 as opposed to on this day. All right. Anything else, guys?
No,
Your
Your
Honor,
Honor.
appreciate it. Have a great weekend.
All right. You too. Be
Thank you.
safe.
Thank you.
Thank you, Your
You
Honor.
too.
Judge.
Are we excused, Your Honor?
You are excused.